Thank you, Kathy, and thank you everyone for joining us today. My name is Jay Organic. I'm an attorney at Schoeneck King. This is, as Kathy mentioned, the first of a four-part series, and today we'll be focusing on concerns for businesses in Western New York reopening during Phase 1 and Phase 2 of New York's reopening plan. There's a lot of information out there, and we've received a lot of questions. We thought this would be a good opportunity to provide some guidance as far as those questions go from both a legal and an accounting standpoint with our two firms. We wanted to address some of the most common concerns that we've heard from businesses in Western New York trying to navigate the reopening process. As Kathy mentioned, if anyone has questions during the presentation, please use the Q&A icon to submit them, and they will be addressed at the end of the program if time permits. Without further ado, I'm going to introduce my colleague, Peter Wiltenberg, to address some of the labor concerns. Peter?
Thanks, Jay, and good afternoon, everyone. My presentation is going to have three main parts. First, I'll just do an overview of the state's reopening process and what you need to do to get back up and running. Second, I'll touch briefly on some things that employers should be concerned about when it comes to bringing people back to the workplace. And third, I'll go over some of the most frequently asked questions that our clients have had as they're going through this process. So first, the reopening. Just as a brief recap, in late March, the governor ordered that all non-essential businesses had to stop having employees at the work site. That meant that a lot of non-essential businesses had to close. Since then, the state has put together a reopening plan that contains 4 phases and divides the state into different regions. So each phase specifies particular industries, and if your region meets the state's metrics, you can begin entering those phases. So Western New York entered Phase 1 last week on May 19th. We're still in it right now. So the industries that are in Phase 1 on the slide there are permitted to reopen as long as they comply with the state's guidance, which I'll talk about in just a few minutes. We don't know exactly when Western New York is going to be able to enter Phase 2. It could be as soon as next Tuesday, June 2nd, but that depends on a couple of different things, how our region keeps doing on the state's metrics, and whether the governor decides that there's actually going to be just 2 weeks between phases. That's initially what he said the minimum would be, but he's also said that it's not certainly that's going to be the case. But in any event, Western New York is going to enter Phase 2 pretty soon. So for the employers in those industries in Phase 2 on the slide there, now is really the time when you can and should start thinking about what you're going to do to get ready as soon as we enter Phase 2 so you can reopen as quickly as possible. So let's go to the next slide, please. So what do you have to do to reopen? I mean, aside from being in a region that's entered the phase that covers your industry, you basically need to do 2 main things. Create a workplace safety plan, and then affirm that you're going to comply with the state's guidance, detailed guidance that pertains to your industry. So next slide, please. What goes into a workplace safety plan? The state has published a couple of different documents for each industry that's entered Phase 1. So one of the things they've provided is a pretty basic template for what a workplace safety plan could look like. So that's a great place to start. But what you really need to look at to create a proper workplace safety plan and really get yourself ready to reopen is the state's detailed guidance that's particular to your industry. So they have issued detailed guidance for each of the industries in Phase 1. And the guidance is a little bit different for each industry, but it's very similar, contains a lot of common elements. And all of the detailed guidances are broken into 3 main areas of focus, which they've decided to call people, places, and processes. So it's 3 Ps, but not to be confused with the 3 Ps of the Paycheck Protection Program. So let's go to the next slide. The people section of the state's detailed guidance generally contains things having to do with physical distancing of employees and how to reduce the amount of contact that employees have when they're in enclosed spaces. So some of the general guidelines it contains are that masks or face coverings have to be worn anytime people have to be less than 6 feet apart. It has occupancy limitations for different kinds of spaces, and these are slightly different between the industries, but generally what they say is that you can't have more than 50% of max capacity in any particular space as based on the building certificate of occupancy. Employers need to have plans to address situations where it's not possible to maintain social distancing. There are rules about meetings, gatherings, or any kinds of times when more than one person needs to be present together in some kind of enclosed space. So that includes things like meetings need to be remote or telephonic to the maximum extent possible. Other kinds of things can be done if that's not possible, but certainly something that employers need to consider. And finally, it talks about all kinds of different measures that employers might take to reduce the amount that people make contact with each other. So that's going to be very specific to the particular workplace. It could be things like creating one-way hallways or modifying or even eliminating some common areas or meal places. It could mean modifications to restrooms. Very different depending on the circumstances, but something that every employer needs to consider. Then the other part of the people section has to do with basically people from outside the office. So it says, first of all, non-essential visitors are prohibited, and employers need to come up with designated areas for pickups and deliveries. Next slide, please. Next, the places section. One of the primary things there covers what kind of protective equipment is going to be required. And a really important requirement there is that employers must provide masks or face coverings for all their employees, regardless of whether the employees are actually required to use them all the time. I mean, there's not a general requirement that everybody has to wear a mask all the time. It's different by industry, so you need to consult the specifics, but generally speaking, the rule is that employees need to wear masks only when they can't maintain distance or if they're not interacting with the public. All employees need to be prepared to wear a face covering in the event that they unexpectedly come into close contact with somebody, but nevertheless, employers need to provide them. Employers also need to come up with measures to limit the sharing of objects. And if they can't do that, there needs to be protocols in place for either wearing gloves, sanitizing the equipment, or other measures like that. Second major component of the places section of the detailed guidance has to do with hygiene and cleaning. The main thing there is to consult CDC and DOH guidance, of which there is a lot. Some of it is very particular to industries or circumstances, such as if there's a positive test within the workplace. So that guidance changes often, and so it needs to be monitored very closely and frequently. Second major requirement there is the employer needs to maintain logs of basically what cleaning and hygiene measures they're taking, when they're done, what the scope is, etc. Then finally, communications need to be created and put in place for everybody. So employees, visitors, customers, everybody who's going to be subject to some of these protocols. So it's very important for employers to think about who in their organization is going to be responsible both for creating and disseminating those communications. Next slide, please. Third major section of the detailed guidance is called processes. And the main thing here is screening is one section of it, and tracking and tracing is the other. The screening requirement means that employers must screen every employee and visitor when they come into the worksite every single day. And the minimum requirements for that are basically to ask them 3 questions. Have you had close or proximate contact in the last 14 days with anybody who has tested positive or had symptoms of COVID-19? Have you yourself tested positive in the last 14 days? Or have you had symptoms in the last 14 days? Only if somebody answers no to all 3 of those questions every day are they permitted to enter the worksite. So this is a pretty onerous requirement that employers are going to have to figure out how they're going to implement. Temperature checking is a permitted method on the screening, though it really only addresses one of the 3 questions, specifically whether you're symptomatic right now. And the employer is required to review all of the responses from the screening every day and maintain a record of that review. So it's also a pretty burdensome administrative requirement. Also, PPE is required for the people who are conducting the screening. Tracking and tracing. The rules say that employers, to the extent possible, should maintain logs of visitors, employees who are going to be entering the workplace and coming into close contact with people, and the log needs to contain their contact info. The reason for this is so that the employer can assist the local Department of Health with contact tracing in the event that there's a positive test in the workplace. Employers are required to report to the local health department and the DOH if there's a positive test in the workplace, and then to cooperate with the local health department's contact tracing efforts. So while it seems like this log isn't strictly required by the rules, it's a really good idea to maintain it, partly because the rules say that you should do it, but also you are required to cooperate with their contact tracing, and it's going to be a lot easier if you've been maintaining a log of who's come into the building and what their contact information is. So next slide, please. So finally, how to put together the workplace safety plan. I mean, it's one thing that we can't overemphasize is it's highly specific, not just to each industry, because each industry has different particular guidance as put out by the state in the phase 1 detailed guidance, but also it's going to be very different depending just on the specifics of what the layout of your workplace is, how many employees you have, what kind of functions they perform, how close they typically are to each other, and lots of other considerations. So it's pretty important to really look specifically at your work site and consult with counsel about developing the workplace safety plan. It's important to continuously update it. I mean, once you create it, very likely the guidance from state and local authorities is going to continue to change. You can start with the basics, the basic templates that the state has published in conjunction with phase 1, but that's really just a starting place, and we really think your workplace safety plan should incorporate that detailed guidance that the state also published. And finally, once that's done, the workplace safety plan does not have to be submitted to the state, but it does have to be conspicuously posted around the workplace, and it has to be made available for an inspection if the state asks for it. And finally, every employer, before you reopen, has to complete an affirmation that appears on the state's website at the very end of the detailed guidance that's particular to your industry. So next slide, please. What to expect next on the phased reopenings. As I said, we're going to be hopefully entering phase 2 pretty soon. It could be as soon as next Tuesday. We don't exactly know when. We don't know exactly what the state's guidance is going to look like. I just checked right before this webinar started and it still hasn't been published, but we're expecting it any day now. Nevertheless, we are pretty sure it's going to be very similar to the guidance that's already been put out for phase 1. The phase 1 guidance has lots of common elements across the industries, and it's probably going to be the same for phase 2 for things like distancing, occupancy limits, screening requirements, contact tracing, hygiene, requirements for visitors, many different things. So phase 2 employers really can start to look at that and think about what they would put into their workplace safety plan now. That will probably get you at least 80% of the way there. And then once phase 2 guidance is published, you can kind of just tinker around the edges and hopefully get back to reopening as quickly as possible. The link for the state's website that contains all this guidance is on the bottom of that page there. So you can look there for the phase 1 guidance and then also check back frequently to see once they publish phase 2. So next slide, please. So next section here that I just wanted to touch on quickly are some things for employers to consider as they bring people back to the workplace. And again, this is really just kind of the tip of the iceberg, and there are going to be lots more considerations, but here are some kind of general labor ones. So repopulating the workforce, especially for those non-essential businesses that have been closed during the pandemic so far. First, consider how you're going to make sure you're complying with all the governmental workforce restrictions. Those are mostly going to be the things that we just discussed. They're going to go into your workplace safety plan, but there could be others as well. For example, OSHA just issued some non-binding guidance yesterday having to do with the construction industry. It probably mostly overlaps with New York's guidance, but that's going to continue to change, and you need to stay abreast of federal guidance as well as probably from other sources. When you're bringing employees back, if you're not able to bring everybody back at the same time, you really need to think about who you're going to bring back first and why. So that could be a lot of different considerations could go into that. It's important to make sure when you're doing this that you are going to document the ways that your decisions to bring people back first were done in an objective, non-discriminatory manner. The Division of Human Rights has already indicated that there could be discrimination claims based on somebody in a protected category being more likely supposedly to have COVID. So that's discrimination claims are something that everyone is really going to have to still be aware of in this context. Consider any legal requirements or restrictions that might affect who you're able to bring back first. There could be a collective bargaining agreement, another contract, or some other legal requirements that affect who you're able to bring back first. Think about how you're going to account for employees who are either unable or unwilling to return right at the beginning. This could be for all sorts of different reasons, and that's a frequently asked question we've been getting from our clients, so I'll touch on that a little bit toward the end of the presentation. And then it's important to think about who within your organization or management team is going to take the responsibility for the increased administrative load that is now being imposed by all those detailed requirements that we just went over. There are lots of onerous new requirements that have to be met for log keeping, communication, screening, contact tracing, all sorts of other things. And it's going to be very important to designate who is going to be responsible for those. So next slide, please. Employers are most likely going to have to deal with increased absenteeism after they reopen. Continued absences related to COVID-19 are probably going to be a feature for the next several months, if not a year or more. So that's going to affect operations, certainly in lots of different ways and in different ways for different employers. It could affect employee morale, lots of other questions. So anticipate how that might affect your workplace. Try to now develop a plan for how you're going to operate with higher rates of absence. Depending on the employer, there could be opportunities for cross-training employees to fill different roles. Maybe it's possible to make more use of temporary workers. Maybe there's a call-in system that could help alert you to absences or to be able to call in workers on relatively short notice. There are lots of different measures that you could possibly take, but it will probably be important to be able to smoothly maintain operations to the extent possible with more people reporting out of work. And finally, make sure you're familiar with the COVID-related paid sick leave laws that have been passed in the last couple months. In March, both New York, through its emergency paid sick leave law, and then at the federal level, the Families First Coronavirus Response Act were passed. Both provide pretty generous paid sick leave, the federal act for a variety of different circumstances, and they apply to different employers. As people come back to the workplace, they're probably going to be making use of paid leave a lot more. So that's certainly something to make sure that you're prepared for. Next slide, please. Finally, consider whether adjustments need to be made to your employment policies. This is a good time to review them. All kinds of different situations are going to come up that may implicate some of these changes that we're talking about. So a totally non-exhaustive list of areas to consider for your employment policies are your attendance policies, your various kinds of leave policies, whether something to do with more flexible scheduling is written into your policy that may need to be changed, your remote work policy, perhaps restrictions or rules about employee travel that are not going to be the same in this environment, and then all kinds of considerations having to do with information technology. So next slide, please. So now on to some of the last section of my presentation, which is some of the most frequently asked questions that we've been getting. So what should essential businesses do now? Essential businesses, of course, have been permitted to continue operating throughout the pandemic. So they can continue to do so. The very confusing thing is that when the state published its phase 1 guidance in its frequently asked questions, it said that essential businesses must comply with the phase 1 requirements. So that is not really clear as to what essential businesses are supposed to be doing. If you are an essential business that happens to be in one of the delineated phase 1 industries, for example, a manufacturer, which is a phase 1 business that also happened to be an essential business, it's pretty clear that you should just follow the detailed guidance that the state published about the manufacturing industry and create a workplace safety plan based on that guidance. However, if you're an essential business that's not in one of the phase 1 industries, according to this guidance from the state, you are supposed to create a workplace safety plan, but it's not clear which one you should follow. So we think a best practice here would be to review the detailed guidance from the various industries, identify the common elements that exist across them, of which there are many. I mean, the detailed guidance is substantially similar for almost every industry. The template workplace safety plan that the state published is the same for every industry. So identify those and try to create a workplace safety plan based on those common elements, or maybe there might be some opportunity to borrow from some of the specific guidance from one of the phase 1 industries that most closely resembles your circumstances. But in any event, essential businesses are now required to follow the detailed guidance that exists for phase 1 industries, and they should create a workplace safety plan. It's not clear when they need to do that by. The guidance didn't say that essential businesses need to stop operating until they do that, but we think it would certainly be a best practice to do that as soon as reasonably possible. It's important to keep watching for guidance specific to your industry. Even if you're not in one of the phase 2 industries, there may be some phase 2 guidance that more closely resembles your circumstances. And then also, just finally, for essential businesses who may have had a large portion of their workforce working from home, consider the implications of all this as they start to bring some of those remote workers back to the workplace to the extent that they do. Next slide, please. How to implement the screening requirement. The screening requirement at its minimum is basically a questionnaire that asks 3 questions of employees and visitors that come into the worksite. So again, those questions are designed to ask whether you've had close or proximate contact with anybody who is COVID positive or symptomatic in the last 14 days, whether you've tested positive in the last 14 days, or whether you've been symptomatic in the last 14 days. That's what you need to do. The state has made it clear that those questions can be asked in a lot of different ways, and actually remote methods are preferred. So some clients are using a phone call-in system. Some are creating apps for their employees to use before they get to the workplace, or some other online thing. It can be done on a paper questionnaire when they arrive at the workplace. Some employers have asked whether it's possible to use a more passive system, such as a sign over a door, or a system by which employees who clock in are deemed to be affirming their answers to the 3 questions just based on the fact that they've clocked in. And we think that those passive methods are not compliant with the requirements for a couple of different reasons. I mean, first of all, the guidance seems to require affirmative responses. The employer is required to review the responses every day and create a record of that review. And finally, visitors must also be screened. So a visitor just coming to the workplace and walking through a door that has a sign above it stating that they're attesting to their responses to these 3 questions, we certainly don't think is compliant. Some of the other requirements that go along with screening, recall, are that the employer needs to set up a method, especially if you're doing an in-person screening that involves a paper questionnaire. You need to set up a system to minimize the amount of congregating that employees have to do while they're doing the screening. That could be something like staggered start times or pieces of tape on the floor like a supermarket checkout line. And that you need to make sure that your employees who are performing the screening have appropriate PPE, which at a minimum needs to be a mask. Finally, customers cannot be required to be screened, and people doing deliveries don't have to be screened as long as they have PPE or are making contact with anybody. So next slide, please. What are the requirements for face coverings? The first important one is that employers have to provide them. It's not clear what kind of face covering they have to provide, but they need to provide one. If it's a cloth mask or face covering, employers can require their employees to launder them, but it's an open question whether those employees have to be compensated for that. Depends on a number of factors. It's highly specific to the circumstances, so we recommend consulting counsel on that particular question. Generally, employees have to wear face coverings anytime that they are going to be coming within 6 feet of another person. And if their job requirements or layout enables them to maintain distance most of the time, they don't have to wear a mask when they're not within 6 feet of anybody, but they have to be prepared to put one on in the event that they unexpectedly come into close contact with somebody. So again, check the industry specifics, as there are certainly different requirements for some different industries on that one. Next slide, please. What are the requirements for the contact tracing log? The log itself doesn't appear to be required. The guidance says that to the extent possible, the employer should maintain one. The log is supposed to record employees and visitors who come into close contact with other people at the work site and maintain the contact information for those people. The idea is that the employer can assist the local Department of Health with contact tracing in the event that there's a positive test at the workplace. It is required that the employer report a positive test to the Department of Health and that the employer cooperate with contact tracing efforts. So it's certainly a best practice to maintain the log with contact information for visitors who come to the workplace. I mean, most likely you're going to have the contact information for the employees, and based on their work assignments, will know which of those came into close contact with the person who tested positive. So especially for visitors, it's going to be important to maintain the contact tracing log. And again, it doesn't apply to customers, though you can encourage them to put their information into a contact tracing log. Same thing for delivery people, as long as the delivery person is wearing appropriate PPE, most likely that means just a mask, or doing a contactless delivery, just dropping off a box outside the door. Next slide, please. And then for the last question that I have here, another common one: what if an employee refuses to return to work? This is going to be, unfortunately, there are really no good, simple answers to this question. Certainly not a one-size-fits-all answer that applies to every circumstance. It's going to be highly fact-specific, and it's going to be a delicate situation. So first, you need to find out why the employee doesn't want to return to work. Is it just a general fear of being exposed to the virus? Is the employee in a higher risk group, such as a person who has a pre-existing medical condition or maybe is just of a particular age? Does the employee live with somebody who's in a higher risk group, or do they have childcare obligations? Depending on what that answer is, it's going to be a different route for how to handle the situation. Then you need to determine if there are any other laws or policies that apply to this particular employee's circumstance. And the most important one, I think, to look at first is whether any of the new paid sick leave laws apply. So as we said before, the Families First Coronavirus Response Act and New York's Emergency Paid Sick Leave Law, passed in March, provide paid sick leave certainly for people who, well, in the case of the state law, who have been ordered to quarantine as a result of COVID, and the federal law, which applies to employers with 500 or fewer employees, provides paid sick leave for people who are quarantining, experiencing symptoms, testing positive, and it provides some considerable paid sick leave for people who have childcare obligations as a result of a COVID-related situation. So make sure you're familiar with those laws and see if the employee who doesn't want to return to work is actually entitled to a paid leave benefit under one of those. Secondly, maybe the reason that the employee is giving could fall under the traditional FMLA paid or unpaid leave analysis. And then also whether the ADA applies. It's kind of a new issue as to whether some of these pre-existing conditions that an employee may have could qualify as a disability under the ADA that would require the employer to see if there's a reasonable accommodation that can be made, so long as it doesn't present an undue hardship for the operation. Just yesterday, I think the local director or the regional director of the EEOC said that claims of that nature are starting to be filed. The State Division of Human Rights has said the same thing. So that's certainly an emerging issue, but it's definitely something for employers to consider. And it could well be the case that you're obligated to see if there's a reasonable accommodation for a person who has a pre-existing health condition and is afraid of getting COVID for that reason. So there really are a range of potential outcomes here, very fact specific, and we certainly recommend that you consult with counsel before taking any actions related to that. So with that, I'll turn it back over to Jay and over to Jeff and Mark.
Thank you, Peter. I apologize. I had some microphone issues there. Thank you for your time and for speaking to that. We did receive a number of Q&A questions while you were speaking. Peter is going to take a look at those and see if there's anything we can address today if time permits. But other than that, they are all good questions that will be addressed either at a future presentation or, if more urgent, then we will follow up with an information release. With that in mind, I know a lot of businesses also have questions regarding relief under the CARES Act, both relative to the employee retention tax credit and loans under the Paycheck Protection Program, and what the effect of bringing employees back to the workplace and reopening may have on eligibility for that relief. So to speak to those issues, we have two tax directors from Freed Maxick joining us. Starting off to address the impact of reopening on the employee retention tax credit, I'd like to introduce Mark Stebbins. Mark.
Actually, Jeff will be covering that topic. So Jeff, if you wouldn't mind, thank you.
I apologize. Jeff Zawada, please.
Mark, you sure you don't want to cover it? Thanks, Jay, and good afternoon, everyone. Like Jay mentioned, we're going to start with the employee retention credit. Now, currently there hasn't been any recent enacted changes to the credit. There is a proposed bill. We'll touch on that shortly, but we thought it would still be interesting to speak about this topic, to just give a brief review, but also to talk about how it could apply to your situation now that you're reopening your business, or now that New York is reopening. But just to begin with a brief review of the credit, it is a fully refundable tax credit for employers, which really means that, you know, you're getting a credit right now of up to $5,000 per employee. It's 50% of the wages, so 50% of a qualified $10,000 of wages. That could accumulate to a large number, which could be more than your employment tax that you're paying on your payroll tax forms. So if you exceed that amount, you're not limited to the amount you're going to be required to pay in. You can get a refund for the excess. That's why they call it a refundable credit. Like I said, it's equal to 50% of the qualified wages, which includes health plan expenses. There is, like I mentioned, a bill that was introduced in the Senate very recently, within the last week, that may increase that limitation pretty significantly up to an annualized $90,000 and apply that to amounts to rehire people that were furloughed or laid off. So keep an eye out for that. There could be some changes coming forward, to this credit. The credit does apply to qualified wages paid after March 12th and before January 1st of 2021, depending if you're otherwise eligible. So at most right now, it's between those two dates. You're not eligible to receive this if you have a Paycheck Protection Program PPP loan. Also, if you're part of an aggregate group and any one member of your group has the PPP loan, you are also not eligible for it. However, if you did have it and you repaid the PPP loan, as some companies have, you can still be qualified for this credit as long as you paid it back in time, which I believe the date was May 14th, based upon the most recent guidance. An important item to note before we move on, which is not in this slide, is for qualified wages, if you do have less than 100 employees, it counts for pretty much any wages you pay them during your qualifying period. If you have more than 100 employees, it only counts for if you're paying them not to provide services. So it's an important distinction based off of your number of employees. Can you proceed to the next slide, please? Okay, the start date and the end date for the eligible employer, this is kind of the crux of what we want to talk about, especially the end date. But just to recap, there are two ways you could have received or become eligible for this credit. And the first was if you're an employer that carries on a trade or business that was fully or partially suspended during any calendar quarter of 2020 due to an appropriate government order. Now, an appropriate government order wasn't a press conference or even a declaration of state of emergency. It had to be an order limiting commerce, travel, or group meetings. So for New York, for instance, there was a disaster emergency declared on March 7th, but that isn't what applied. It wasn't until March 20th that you actually had the limitation, a partial limitation on commerce. That's when they limited the workforce for non-essential businesses to 50%. So March 20th basically is in New York State our start date, for probably all businesses that otherwise qualify. For that piece, the end date really is when the government order is lifted. Now, there isn't a lot of guidance on what constitutes the lifting of a government order, but as we start entering these phases now and we're allowed to come back to work, unless further guidance says otherwise, it's probably pretty clear that as you're allowed to go back to work, you're no longer under this order to limit commerce, travel, or group meetings, and therefore your credit would end at the start of this the phase, whatever phase your industry belongs in. So now we have a defined end date for this credit. However, there was another way you can qualify for this credit, and that is if you had a significant decline in gross receipts during a calendar quarter. Comparatively, from 2019 to 2020, in each quarter, if you had a greater than 50% reduction, you could qualify even if there wasn't a government order, and that would last until you go back over 80% of that amount. The good thing about that, I mean, it's not a good thing about that, but the good thing about that comparative to the other requirements is that you would generally get to the end of the quarter when you reach that 80% limit. So if you have a 50% reduction in gross receipts in Q1, and then you're back over 80% in Q2, your end date really would be the end of the second quarter, June 30th, whereas it appears for the first test, it probably would be the day your phase begins. Can you please move to the next slide? So where does that bring us for New York? New York was broken down into 10 regions. And each county was part of a region. So they didn't do it based off of county by county. They broke it out into different regions. There were 7 metrics that had to be satisfied to reopen. Not really pertinent to this discussion. We know that we've met them. That's why we're in phase 1. And there's going to be at least 2 weeks in between each of these phases. And according to them, that is to allow them to monitor the effect of the reopening to ensure that the hospitalization and the infection rates are not increasing before they move to the next phase. So off to the right, you see the different phases and the different industries for each of the phases. So in the Western New York region, in the Finger Lakes region, right now we are in phase 1. So the construction, manufacturing, wholesale trade, they were all they were all allowed to, begin business again. As Peter mentioned before, we are approaching phase 2, which are like our professional services, finances, etc. And then eventually we get down to some of the more fun stuff in phase 4, which is the entertainment, recreation, and education. So hopefully our kids can go back to school before school starts next year. Okay, can you move on to the next slide, please? So the key dates for the employee retention credit, and this is the gist of it. Now, the first bullet point off to the left of your screen is basically what we've already talked about. Our start date really was March 20th. I listed out the Western New York and the Finger Lakes region because my assumption is that's where most of the attendees to this presentation are from. The Western New York region being Niagara County, Erie, Chautauqua, Cattaraugus, and Allegheny. We began phase 1 on Tuesday, May 19th. So I put down right underneath that when phases 2 through 4 are eligible to begin as long as we meet all the requirements. So the earliest dates really would be June 2nd, June 16th, and June 30th for those other dates. The Finger Lakes region or Rochester, the Rochester area began 4 days earlier, which was Friday, May 15th. So their 4 days could start a little bit earlier than ours. So they may enter in phase 2 a little bit earlier than us, which may be this Friday, tomorrow, May 19th. So I know where I may be going to get a haircut because I believe all the salons and everything are phase 2 industries. Couple items not listed. There are special rules for multiple locations. So if you have locations in both of these jurisdictions or locations in one of these jurisdictions and somewhere else across the country, there are special rules that could apply to when it technically ends for you. There are also special rules on claiming the credit. You have to pay in your payroll taxes more frequently than you actually file the payroll tax forms. So if we needed to wait until we filed our second quarter form to start getting our credits, we'd have to wait till July to start getting our refund. There are ways to reduce or short pay your payroll tax requirements or request in advance if your payroll tax obligations were not equal to and exceeded the amount of your credit. Bear with me 1 second. That actually, there is a about 90 plus question and answers with regards to the this credit on the IRS website where I got a lot of this material. So if you have any questions, please do let me know. But at this point, I wanted to hand it off to Mark to speak about the PPP.
And thanks, Jeff. And so, yes, and the last topic of interest that we wanted to address with all of you on the webinar today as Western New York reopens deals with the impact that the Paycheck Protection Program may have on the element of the amount of forgiveness. And so, as you may or may not be keenly aware, within the CARES Act, the Paycheck Protection Program, or the PPP loan provisions, have a very important element that's associated with it, which deals with the amount of forgiveness that's eligible for the loan itself. And so many businesses that avail themselves of that program and are reopening or have reopened need to address how the forgiveness elements impact that amount. What we do know is on May 15th, the SBA released the first form, the 3,508 form, and banks have the option of using that form or their own form for purposes of the forgiveness application. We're suggesting that and encouraging businesses to reach out to their financial institution to see which form they will be using. Again, that's either the 3508 or the bank's own form itself. In addition, last Friday, May 22nd, the SBA issued their 12th interim final rule. And that final rule that was issued last Friday supplements all the previously posted interim final rules going all the way back to the beginning of April. And so really, this interim final rule was the purpose of which was to assist the PPP borrowers with respect to the preparation and submission of that loan forgiveness. And so, when we take a look at the 8-week covered period that the PPP forgiveness covers, some of the first loans were dispersed on April 3rd. And if we count 56 days from April 3rd for that 8-week period, actually today is the 56th day for that 8-week covered period. So on this very first slide here, I wanted to shift our focus now just a little bit on the specifics for the forgiveness element of the PPP loan. and again, addressing the categories of costs that are eligible for forgiveness. And the most important and largest of which deals with payroll. And we do know now that the SBA in that interim final rule also added some additional categories of definitions for salaries and wages. And I've highlighted that here on this slide. And so we also know that amounts paid for furloughed employees, amounts paid for hazard pay, as well as bonuses are also all eligible for the definition of payroll costs and eligible for forgiveness. Keep in mind, though, that all amounts for salaries and wages are subject to an annualized cap of $100,000, so please keep that in mind as well. Apart from payroll costs, though, the three other categories of eligible costs here we've just included deal with the mortgage interest payments for covered mortgages, rent on covered leases, as well as utility costs, and we'll talk a little bit about those other costs in just a few minutes. A couple of other key factors here to keep in mind that I've included on this slide, one of which deals with the fact that the SBA early on back in April had indicated that no more than 25% of those three other categories other than payroll can be used and forgiven for purposes of the forgiveness application. In addition, there's two other sort of computational amounts that are included here. The first of which deals with the fact that if an employer has reduced an employee's payroll by more than 25%, the borrower has to reduce the forgiveness by the amount that's in excess of that per employee cap. In addition, there is a quotient formula based on an FTE ratio that needs to be determined, and I'll be covering that in just a moment as well. So those three pieces are very important for purposes of determining how much your loan forgiveness can be for purposes of the eligible costs. Jay, next slide, please. So again, with the interim final rule issued late last Friday, and as you're looking to either reopen or you have reopened, a couple of very important definitions were added in that interim final rule. The law itself originally included the definition of incurred and paid during that 8-week covered period. Well, the SBA has now included, and I've highlighted here, the terminology incurred and or paid during the 8-week covered period, that 56 days. And for the borrower, that 8-week, again, begins on the very first date that the first dollar of loan is dispersed. For payroll only, a borrower can instead use what a new definition was created in the interim final rule is called the alternative payroll covered period. So it's a separate 8-week period other than the original definition of covered period, not to make things any more confusing than they already are. But this alternative payroll covered period is really an administrative ease for purposes of payroll filings. And so this added covered period now is determined by the first day of the first payroll cycle that begins in that 8-week covered period. So it's important to take that into consideration to determine whether or not the amounts that you're incurring in either the 8-week original definition of covered period or this alternative payroll covered period is more beneficial to you. In addition, the SBA included this element of a grace period. So what is meant by that is to the extent that you've incurred payroll towards the end of your covered period, either definition of covered period, you're still able to include those costs as long as they are paid on or before the next regular payroll date. So really what we're looking at here is the ability to include more than just an 8-week period of time for purposes of the eligible costs for payroll. Because again, it's amounts that are paid. So you may have included incurred payroll prior to the 8-week period, but ultimately paid that within the beginning of your 8-week covered period, time period. And then also the payroll that you've incurred towards the end of that 8-week period is eligible as long as it, again, is paid by on or before the next regular payroll date. Next slide, please. So for purposes of the PPP forgiveness, it's important that we stop and talk about an element of the reduction that could occur here. And what's important is a quotient formula, which deals with the full-time equivalency. And what we now also know, both from the application process that was issued 2 weeks ago, as well as the interim final rule last Friday, when you're looking at an FTE, the SBA has now defined that as a basis of a 40-hour test. And so the quotient formula that was included in the CARES Act law tells us that we need to take a look at the 8-week average FTE, which is your numerator, over at the election of the borrower, one of two different reference periods. And that first reference period is the 4.5-month FTE average going back to February 15th of 2019 to June 30th of 2019, or, if beneficial, January 1st to February 29th of 2020, that FTE average. So you want to make sure you're stepping through that formulaic quotient formula to determine which is going to be more beneficial to you. In addition, the SBA has included an administrative ease for part-time employee factor determination. And the borrower can simply take a factor of 0.5 and apply that to every part-time employee. It's not an elective employee by employee. It's every single part-time employee. The borrower can elect this factor of 0.5 instead of actually doing the computation. So again, as I talk about some planning towards the end, keep that factor in mind. And so you're going to include all your FTEs. You're going to aggregate them for each of the selected reference periods, and then compute your FTE quotient formula on this basis. Next slide, please. Some additional favorable guidance was issued as well that I've included on this slide. Many questions had been raised. What happens if, in fact, and I think, Peter, you had alluded to this, if, in fact, you made an offer for reemployment, or an employee has voluntarily resigned, or you may have actually terminated an employee for cause? What happens to your FTE computation formula if, in fact, one of those categories applies to you? And the good news is the SBA has said there will be no reduction in that FTE if an employee falls in one of those categories. The important thing that the SBA has outlined in their guidance is the fact that you maintain documentation. Maintain documentation for your offer of reemployment, the voluntary decline of that offer, and making sure that the employer also notifies the state unemployment office of that decline in offer as well. So make sure you've maintained documentation along the way related to that. In addition, the compensation reduction. Keep in mind, as I mentioned earlier, that you must reduce your forgiveness amount eligible if on a per employee basis their compensation was reduced by more than 25%. And that leads into this other very important element that the SBA provided guidance on, which deals with the fact that we now know that there is no double penalty. So what do I mean by no double penalty? Well, if you've got compensation reduction and an FTE reduction, the compensation reduction will only apply if, in fact, the FTE reduction does not for that employee. So said differently, if in fact you're paying an employee on an hourly rate and you haven't reduced that hourly rate, but have in fact reduced the number of hours, then you're only going to be subject to the FTE reduction and not the compensation reduction. So also keep in mind that I've included as part of this last section on the slide that no reduction in forgiveness will apply if in fact both the FTE and compensation reductions are restored by no later than June 30th of 2020, when you're comparing that to the safe harbor that they've outlined as being February 15th, 2020 to April 26th, 2020. So that's a very important factor that we want to make sure businesses that have run into difficulty with FTE computations and or wage reduction, that you still have the ability to restore those by June 30 to avail yourselves of full forgiveness. Next slide, please. Just wanted to take a moment to address some additional other cost guidance that was issued in the interim final rule. Again, the terminology of incurred and or paid was included for other costs. So I'll highlight that in just a moment. So the amounts that you pay during your covered period, again, for mortgage interest, for covered leases and utilities, as long as you pay those during the covered period, those are eligible costs, as well as those that are incurred during the covered period and paid on or before the next regular billing date, even if that occurs after your covered period ends. So what does that potentially mean? That means that these other cost categories, with the exception of interest, really will allow a forgiveness enhancement based on more than just 8 weeks of other costs when you think about it. So to the extent that you receive utility bills after the beginning of your covered period, but those utility bills really related to amounts incurred prior to the 8 weeks, will avail yourselves of eligibility related to those costs, as well as utility that you're incurring towards the end of your 8-week covered period that you end up paying afterwards. And so keep that in mind. And I think one additional item I wanted to highlight too, as it relates to covered leases, deal with the fact that the SBA has overtly stated that tangible property leases also qualify for purposes of eligible costs, which means that manufacturing equipment, construction equipment, office equipment, and or auto leases would all fall within that category of eligible covered leases. Last slide, please. So what are some things to keep in mind as you're considering planning for maximizing your PPP forgiveness as businesses are reopened or are reopening? And I've mentioned a few of those as I've covered the slides, but just wanted to reiterate some of those right now with you. And so first and foremost, make sure that you're maximizing to the extent possible the $100,000 annualized per employee limit, as well as the additive health insurance and pension funding on top of that $100,000 cap. This is also enhanced by the fact that we have really the opportunity to exceed 8 weeks of covered payroll, considering the change in language now for incurred and or paid. In addition, consider your quotient formula for forgiveness reduction, meaning that your FTE count is very important now, as well as your compensation reduction. So as you're looking to bring employees back, take all this into consideration for purposes of how it's going to impact your FTE quotient formula. Things to consider, as I mentioned earlier, is the administrative ease of the 0.5 part-time factor compared to the actual. Also consider the alternative payroll covered period as opposed to just the defined in the law 8-week covered period. Also consider the flexibility on the reference period elections for the denominator of that quotient formula. 2019 versus 2020, what did your FTE equivalency look like in those two reference periods? In addition, you still have the flexibility to restoring employees up to June 30th, as well as that wage reduction amount to fully receive forgiveness on the PPP. And so lastly, on the non-payroll cost side, again, we have 2+ months of eligible costs. So look at what you're incurring and paying related to those other costs. Consider also the tangible property leases that I mentioned earlier, as well as consider not submitting costs to the extent that they're going to hit that 25% threshold. And with that, that concludes our discussion on the PPP, and we've hit 1 p.m. So Jay, I'll turn it back to you.
Thank you very much, Mark, and thank you, Jeff, as well. A lot covered there, and I see that you both addressed some questions as they came up. So thank you for doing that. I know we are now at the end of the allotted time period. I was going to allow Peter to quickly just address a couple of questions that came up multiple times. So, Peter, would you like to answer some questions I can present to you very quickly?
Sure.
I know one thing that came up a couple of times, are temperature checks actually required? Do employers actually need to conduct those?
Nope, they're not required, though they are specifically named as a permissible method to use for the screening. So just keep in mind, though, that a temperature check is only going to address one of the questions in the screening, namely whether an employee is currently symptomatic. It doesn't answer whether they've tested positive or been exposed to somebody who has in the last 14 days. So not required, but you can do them as part of screening.
Thank you. Another question, do essential businesses that have been operating during this period need a reopening plan? Do they need to make that affirmation that New York State requires?
So on the reopening plan, the state has said that essential businesses need to comply with the phase one. They need to meet those phase one requirements that appear in the state's detailed guidance. So the state has not specifically said that that means they have to create a workplace safety plan, but we certainly think it would be a best practice for each essential business to do so because they have to comply with all the detailed requirements, and that's probably the best way to ensure that you're doing so. And we also don't know for sure that the state won't later say that, in fact, you did need to have a workplace safety plan. So definitely, we think it is a very good idea for essential businesses to create one as soon as possible. On the affirmation, no, you can only do an affirmation if you're in one of the industries that is part of a phase that has been part of the opening. So if you're an essential business that's not one of the industries in phase one, you can't do the affirmation right now. If you are an essential business that is also a phase one industry, then yes, you can and should do the affirmation.
Okay, thank you. And one final question that came up, has New York State put forth any restrictions on business travel?
No, at this time, there's nothing in the detailed guidance about business travel, but I would definitely encourage everybody to keep a close eye on CDC and state guidance on that to the extent it exists elsewhere or if it changes in the coming weeks.
Okay, thank you very much. We have now gone a few minutes over, so I apologize to everyone for that. There were some questions that we did not get to that we will absolutely address. As I mentioned at the beginning, this is an ongoing series, and we will address them either in the next installment or prior to the next installment. So thank you, everyone, for paying attention, and thank you to our speakers for speaking today, and we hope to see everyone at the next step in the series.